How we doing, everybody? This is Raymond DeLeon with Smooth Operation of Law. And I just want to let you guys know that today I'm going to do a audio and a visual on mortgage loan fraud and how to sue for it. So that is any type of mortgage loan fraud that the bank does when you have a mortgage. People are oftentimes very tired of having to pay these bankers, and these bankers are running around doing whatever the hell they want, whenever they want. We're making pleadings, or you're making pleadings, or whoever's making pleadings, and the court's not listening because you got a contract on the table, and the bank is enforcing that contract. And the only thing that judge wants to do is see what's the violation or the breach of the contract, regardless of any type of leveraging facts that you might have. So I'm going to go ahead and take about 15 to 30 minutes to show you very briefly how to go about suing that bank and getting that judge to listen to you when you open up your face in that courtroom and provide your pleadings without hesitation from that judge to do so. If you are interested in any of the articles that have been written by myself, you can find them up. You can look them up at Smooth Operation of Law's Facebook. And here's a whole arsenal of articles that have been written. I'm going to do the mortgage loan fraud. And this one had 1,152 people reached. So I hope that this visual and audio will be enough to make sure that you guys understand what was being said when you read it. Please also make sure to subscribe to the YouTube channel. Okay, these videos will be there. I'm going to make sure that when I post this video up on Facebook today, which is New Year's Eve, so Happy New Year's, I will post it via the link to this YouTube channel. Trying to grow it. Like, share, subscribe, comment, and if you have nothing nice to say, still comment. Nobody cares. You can't argue it because I'm going to put the facts on the table. I dare you to argue it. Okay, so I'm at WikiHow. How to sue for mortgage loan fraud. Mortgage loan fraud is a predatory lending scheme, and it has been a problem for years. As a consequence, many people are pressured into getting loans they wouldn't normally qualify for. You may have been tricked into taking out a high-interest loan, or you might have been sold a house using a false appraisal. That means the value of the house, okay? They might have sold you the house as if it was oceanfront property, and they might have given you the price along with it in your contract, when actually the house is located by a landfill, by a poor neighborhood, and the bank's just trying to get more money out of you. All right? Gathering evidence for your lawsuit. Okay? Identify the illegal lending practices. Okay? They might encourage you to include false information on your mortgage application in order to get the loan, pressuring you to accept high-risk loans such as balloon loans or those with interest-only payments or steep prepayment penalties, convincing you to refinance your loan several times, charging excessive fees for non-existent products or services, asking you to leave signature lines blank, not providing you with certain statements such as whatever comes inside of the contract upon signing, and using a false appraisal to sell properties for more than they are worth. Watch out for common fraudulent lending schemes, okay? And these lending schemes are foreclosure rescue schemes, high equity conversion mortgages, loan modification schemes. Document the fraud, all right? Make sure you get a copy of the police report if you contacted the police. If you've noticed any one of those frauds, a copy of your credit report, a copy of your loan agreement, emails, and letters from the perpetrator of the fraud, any other relevant documents. Write down the memories of your conversation that you had with them. You could meet with a lawyer. Okay, discuss what remedies are available. You might get a court order not to sell your house. monetary compensation, punitive damages, consequential damages for those injuries. And you can also take state and federal agency action. All right. Contact the state attorney general's office, file a complaint with that attorney general. You can file a complaint with the state bar. If you worked with an attorney and you feel like they defrauded you, file that complaint with the state bar. Okay, you cannot file a complaint simply because you think your attorney did a bad job, so you better know that they're not listening to you. Okay? And how do you know they're not listening to you? If you're presenting the shit that you would present to the judge and the judge is ignoring it because there's a contract at bay, but you know that there was some fraud as listed above, you might want to make sure that that attorney is not working for that court. So go file the fucking complaint at the state bar. Okay, report the fraud to the Bureau of Real Estate. File a complaint with the FTC. Okay, and also the CFRB. Draft your complaint. Complete it. File it. Pay the filing fee. Serve a copy on the defendant. File proof of service to prepare for trial. You got to read the defendant's answer to your complaint. Request additional documents if you need to with the subpoena by doing a fact finding. Okay. Draft a list of witnesses if there are any. Prepare your exhibits. Consider the settlement. Most of the time they will settle. Sit in on your trial and then go into trial. Make an opening statement. Present your case. Listen to the defendant's evidence and wait for the verdict. I'm skipping because this is stupid. File for an appeal if they don't fucking give you what you need. All right, so here's the deal. I'm going to show you, after I've explained that process, a document from the DOJ. And I'm going to show you how severe this is. Okay? United States. Okay, wait, hold on. This mortgage fraud document comes directly from the United States Department of Justice. Okay? So you can see that. Hold on, I'm highlighting it. You can see that right here. Good to go? All right. The first subject, and I'm not going to go through all these subjects, okay? But, I'm going to go through all the subjects only at the table of contents. And then I'm going to go through some portions of the subjects inside of the document, but I'm going to just scroll to them just to get it out the way immediately. So, how to commit mortgage fraud. Okay, it's going to explain that to you. Finding the smoking gun, which is actually developing the evidence. Okay, using community outreach to find and prosecute the mortgage fraud. That is going to the state attorney generals or taking federal or state agency action, as discussed in the WikiHow article. Okay, then you got making choices, which is charging and plea negotiations. That's for the attorneys. Civil remedies for mortgage fraud. The civil remedies, okay, here, let me highlight that if I can. There we go. Civil remedies for mortgage fraud. Those are the penalties that we're going to discuss here. But we're not going to go through all of them, but I'm going to give you an idea as to how much money you can make off of that mortgage by being able to prosecute it. And we have the mortgage fraud terms, participants, and documents. That's going to be the closing contract, okay, that's going to allow you to be able to review, which is your closing documents, or the documents they gave you at closing. You are to review that and inspect that. And based on what we said in the WikiHow, based on what we discussed when we looked at the WikiHow page prior to this document, you will be able to say, okay, you know what? My document has this in error, that in error, and this in error. So you know what? Pursuant to the penal codes located in the civil remedies section, when you sue the bank, you will be able to say, well, this is what they did. Here it is on the document, on the closing paperwork. This is what they failed to give me, what they did give me. And this is the verbiage right here. And pursuant to that, it's illegal according to this statute. And you can actually take preemptive action. Like, let's say they want to foreclose on you, but you're not even in court yet, or you're in a non-judicial state. You can actually stop the foreclosure by inspecting your contract and taking preemptive action, filing a suit. And that suit can injunct or stop the bank from either foreclosing. And if you can prove the fraud, you will be able to ultimately settle with them and keep the house. And as a matter of fact, if the contractual breach is so illegal, then it becomes an unenforceable contract. That unenforceable contract means they have no contract. One of the biggest issues that people tend to do is that they go to court arguing all this, there is no money concept. There is no cash. There is no actual interest in this loan because I just signed these documents. And when I signed these documents, you guys just credited me a credit, but you never gave me any actual money or lent me anything. You can't do that. That's called vapor money theory. And actually the DOJ has a protocol to shut that argument down. With that being said, let's look at some of the topics real quick. Okay, how to commit the fraud. A lot of times banks will find a house and a buyer who's unknowing, arrange the sale, and then when once you are applying for a mortgage and you got the contract, you're going to have to team up with some cooperative, understanding professionals. Why? Because you'll need a mortgage broker and an appraiser. Now, you might find a mortgage broker for you that's good, but a lot of times the lenders may seem to be suspicious of everybody. And so they ask a lot of questions, okay? And even the best lender will ask some questions about income and debt. You may need help. You may need to help the buyer come up with some of the documents. So if the parties are telling you like, hey, I'm going to help you with the documents, right? Because you might not have these taxes, you might not have these things, bank statements or stuff. They will make them up. That goes into the leaving certain things blank or providing false information just to get you into the deal. So if they did that for you, you can sue them. Okay, so let's say you sign. You can still sue them because on their end, they weren't supposed to procure that loan that way. So if you went there and they had given you some help with missing information, you will be able to actually come back on them retroactively. Okay, and then there's getting the appraisal and the closing and after closing. And so those are ways to commit it. Falsifying documents, falsifying the appraisal, the bank trying to get you into the loan with shammy type of ordeals, and pretty much you might not know, but you might think they're on your side, but that's actually illegal and you can use it to your benefit. Does it make you an accomplice? Well, here's the deal. Not really. Because the point is that the bank is the one that knows. You are not. So when you're going in there and purchasing in good faith, they are too supposed to operate in good faith. And if you realize that the bank did something illegal, you could say, whoa, they did this illegal. Yeah, I'm coming clean. No, wait, what are you doing? And then you become pretty much a fact witness to their crime as opposed to a defendant as part of the scheme. Here's the other thing too. In order to find a smoking gun, okay, you got to follow the money. The money flow in non-fraud purchase transaction, okay? Sometimes there'll be a scenario where a seller with the house on the market has a fair market value of $100,000 and a buyer offers to buy the property for the $100,000 and acquires an 80% loan to value loan, thus providing $80,000 in lender funds for the purchase. The borrower must come up with the extra $20,000 down payment, generally referred to as cash from borrower. Okay, if the seller has an existing mortgage part of the total, $100,000, $80,000 from the loan and $20,000 CFB will go to pay that off, and ignoring the closing costs for ease of explanation, the rest of the proceeds will go to the seller. If there is no existing mortgage, the seller correctly keeps the full $100,000. Money flow in a fraud for property scheme. Let's change this non-fraud scenario into a fraud of property scheme. The seller wants $100,000 and the buyer wants to pay $100,000. But does not have the necessary CFB. The buyer suggests to the seller that the price be inflated to $125,000. Now the buyer gets 80% loan that provides $100,000, 80% of $125,000 in lender proceeds, with $25,000 due to the buyer-borrower. Due from the buyer-borrower. Remember that the seller only wants $100,000, but receives a total of $125,000. When the loan is funded, the seller can give the extra $25,000 to the buyer or borrower to be used as a CFB. The seller is happy because he ended up netting $100,000 asking price. The buyer-borrower is happy because he got the house without having to come up with any down payment. The victim in this scheme is the lender who bought it, who thought it was lending 80% on the purchase of a house worth $125,000. The lender was actually lending $100,000 on a house worth $100,000, or making a 100,000% loan. If the loan is not paid off, the lender will likely suffer some loss because the 20% equity cushion, the amount of CFB the lender thought was present, did not exist. So what is this? We're playing musical chairs with the percentages, right? Okay? That's what's happening. The lender isn't making anything. So the lender gets fucked out of money. And that's what's happening here. So sometimes banks will sit there and they will create all of this loophole. I will lend you this, I will do this, or I have an interest in this because I loaned that. And the lender isn't really lending the complete amount to make the full amount. So everybody's just kind of running around the lender in order to make it appear as if the lender is getting whatever interest or value that they were supposed to get, and they didn't make their proper money. That's all that is, in a nutshell. Okay? So I'm going to keep skipping, and we'll just go down to evidence of fraud. Proving a mortgage fraud case must include proving the money flow. That's essentially what's going on. However, there are other material facts involved in the lending process, such as appraisals, source of funds, borrower qualifications, and title history of the property that are often falsified to accomplish the fraudster's desired money flow. These material facts and money flow are evidenced in a number of source documents that will be available in the typical mortgage fraud investigation, such as the closing agent file, title documents, closing instructions from the lender, the HUD-1 form, broker file, other documents, comparisons across the file. Okay, you got the lender file, which is the the application HUD form. Then you have the underwriting. Then you have the HUD-1, right? Appraiser file, borrower and seller files. Okay, and then the conclusion is that hopefully this article has given you some valuable ideas where to find your smoking gun. Okay, and so that's pretty much how it is. All right, so I didn't go through everything, but at the end of looking at this document, I'm going to show you how to cause. What did I say? How to cause all of these things to be proven. Okay, I'm going to show you how to do it. A one-stop shop, easy way to do it. I'm just going through a few of the ways that the DOJ looks at it, okay? And if I might have explained anything that might confuse you, well, I'm reading it off the document. I'm just citing specific portions of the document and reading it expeditiously. So the words are there. This isn't my document. This is the DOJ's document. This is how they prosecute mortgage lender fraud. The civil remedies are what you can recoup for the most part, based on a lot of these mortgage lending frauds, or what a prosecutor can get paid to the state or agency that they operate for, i.e., for prosecuting the case. All right? And this is going to be the last thing right here. We don't need to know about charging pleas, but they do have all of the statutes, okay, that the bank committed in order to prosecute them criminally, as you see on your screen. Okay? All of the Title 18 actions that they can take against them. Money laundering, conspiracy options, okay, additional statutes, when to charge, okay, plea negotiations, conclusion. The civil remedies are for you. So fortunately, extremely powerful civil remedies are available to supplement criminal prosecutions in providing both punishment and deterrence. And the article will go over the basic overview of 3 weapons in their civil arsenal. You got FOREA violations and false claims violations, and injunctive relief is available to enjoin fraudulent activities, so you can stop people from perpetuating it. In a civil case, all you need is a preponderance of evidence. Okay? Hold on. Let me highlight it. Jesus. There it is. A preponderance of evidence. Burden of proof that applies when a civil action is brought. What a preponderance of evidence is that you don't have to prove them guilty beyond a reasonable doubt. What you must do is prove that it's more likely than not that they did commit the act. All right? And if you look down here, okay, you will see Title 12, Title 18, violations listed. Okay? And you can look at that as I'm scrolling down. You can stop the video at any time. Okay, so on and so forth. All right. So what's the point? The DOJ document that I showed is exactly what the definition would be when you're looking at gathering evidence for your lawsuit in part 1 of the WikiHow. Okay? There is an extensive document. If you need that document so that you can read it yourself, because the way I explained it was too fast, even though all I was doing was highlighting potential actions that you could take, you must contact me. Period. You must contact me. And you can go to Smoothoperationoflaw on Facebook. Type it into Google and you can find it. First link, it'll pop up on Facebook. Google will bring up the Facebook page, click it, and you will be there. Now, contact me via Messenger, preferably. Now, here's the deal. I showed you how to sue for mortgage loan fraud. I showed you there was a DOJ document that explains all of the intricacies. That sounds very complicated. Well, it's a little bit complicated if you don't know it. But as you saw, the DOJ document was about 37 pages. This document here is on the internet. It's at WikiHow. I read it all in front of you. Take the time and you'll be good. So what is the point of going through all this? Is the difference between you keeping your home and getting a few $1 million. A few $1 million in compensation. So losing your home and a few $1 million in compensation and possibly keeping the asset. That's the difference here. So instead of going to self-help groups, you can look this up right on the internet. Period. Here's the other thing. Yesterday I gave a class on common law trademark, which is an unregistered trademark, versus common law copyright. Could you use the trademark from your trust in order to leverage the contract? Let's say there is no fraud, but leverage the contract because the bank is a trustee. Your team are trustees in the same fucking market. By action, are we not? That means they are providing a service that is a competitor to your service behind the name on the document, which happens to be a trademark. The trust itself is not you. So actions that the trust can take because it's not obligated to the contract is different than what you could take by being obligated, or as a party who is obligated to the contract. There we go. Let me correct myself. So the trust can claim trademark violations against the bank as trustees because the trust has trustees who, pursuant to FRCP 17A, have standing to sue as a real party in interest over their asset. The mere fact that the bank is a trust and your trust is a trust and the trustees in both entities are where the dispute is and they represent their entities, you can hit the bank for unfair competition because they used your trademark in order to secure a transaction on their documents. Yes, it's an individual that might have signed it, but that does not mean that the bank is not in collusion. So, does the trust have to sue the man or the woman? Here's the thing. You cannot sue an individual who has the name because anybody born with the name, that's part of their identity. The nature of your argument against the bank is not so much that it's an identity. You're attacking the fact that there was a secure transaction that took place and it's unfair competition because of the services that you guys provide. If you get what I just said, then essentially you can use the trust to attack a loan that it is not obligated to and leverage the contract out of existence. You can just simply sue for an injunction on the transaction of the contract and therefore not allowing the bank to do what? To claim against the borrower. But what happens when you do that? Can you get it adjudicated? Absolutely. Because again, you are not a borrower as a trust. You are just claiming that your trademark is in circulation and you're wondering why a competitor is using your name to secure deals behind that trademark when you are the one with priority security interest. What happens if you leverage that contract, you actually get the injunction, and they have to cease and desist using that agreement? Well, the loan that they used to have that gets blown off the face of the earth becomes an heir loan. And an heir loan, according to the definition from Investopedia, is an heir loan is a fraud scheme in which a mortgage broker invents both a property and a borrower in order to earn false profits. Everything that they thought they had against the individual man or woman is no longer in existence, and therefore there is no borrower, because they just got that fucking name muted off of those documents and a court injunction to shut it down. That is how you discharge debt. I'm going to say it again. That is how you discharge and delete debt. Once that happens, everything that was in the WikiHow immediately becomes true. Dot. It immediately becomes true. There is no fucking borrower. So it is a mortgage loan fraud with invented parties. Did the man sue? I'm going to say it again. No, he didn't. Not at first. The trust sued a competitor, and as a result, the man ends up with the burden removed. Interesting. So I'm going to conclude that, or this video right now. And for all you skeptics out there, I pulled up the definition. Yesterday I talked about the trademark, so go ahead and check that video, share that video. And if you can put 2 and 2 together, Happy New Year's. Any questions or comments, go ahead and hit me up on Messenger and on Facebook. And the link will be in this description on how to get to said Messenger or Facebook. Good day.